Ohio says that it would be impractical and even unlawful for it to comply with the collective bargaining order issued in this case and presumably in others as well, and you dispute that. Would you characterize it as an open question on which you have the better of the argument, but there's a risk that Ohio would be right, or do you think Ohio is just crazy to say it?
I think the latter.
With all respect to General Flowers.
I think the latter, Justice Barrett. I think the Sixth Circuit was correct. What I take petitioners to be complaining about is the portion of the order requiring them to reinstate union dues withholding. And what happened is that although DOD may be responsible for the withholding, the petitioners are responsible for having on hand and filing the forms necessary for that. So what petitioners did in this case is they filed forms canceling dues withholding on behalf of dual status technicians. They signed those forms. And that was something that was not permitted under the relevant statutes and regulatory provisions. So I think it's fair that the Sixth Circuit said, to the extent that Ohio took that action, which was outside the law, that they can be required to correct that action. And I think in any event, though, that's really a sideshow in this case, because petitioners haven't in any way suggested that they're unable to comply with the remainder of the FLRA's orders. And so to the extent there's some minor thing that on the facts of this case you might think problematic, doesn't in any way undermine that generally there aren't a problem with FLRA orders.
Well, I mean, I guess the reason why I ask is that you've pointed out the real practical problems that would arise if DOD was the one sitting on the other side of the bargaining table. And Ohio says, well, wait, there are real practical problems and legal problems that arise if we're the ones sitting on the bargaining table, because then the FLRA issues orders that we actually can't carry out. And even if the Sixth Circuit was right about the order in this case on that particular issue, can you imagine other things? I mean, is Ohio right that there would be a practical problem whichever way you go? Because there might be a number of things that are controlled by DOD regulations that the Ohio Adjutant General just can't control.
I'm not aware of anything, and I actually think the onus is on Ohio here, because we've spent 50 years collectively bargaining, and there are many Court of Appeals and FLRA decisions about this. Ohio hasn't been able to identify any difficulties or any sorts of things that they couldn't comply with in any of those other orders.